reporter. That's Ziyanda Ngobo, live for us in Pietermaritzburg. Ziyanda, good morning to you once again. I've just had a conversation with the spokesperson of the Jacob Zuma Foundation, Mr. Manyi, who says this is a sober decision taken by Judge Piet. I guess the ball is now in the court of the NPA as to whether or not they're going to be moved by this decision and perhaps ask Billy Downer to step aside from this case.
Well, Xoli, we would have heard from Advocate Ngabab Tilezi saying that they have every intention to still pursue the removal of Billy Downer from this matter. The date of the 17th of April has been set down for the start of the trial, and it would seem that the new judge is Judge Nkosinathi Qhili. He's also presided over a few matters within this court. He's also quite a senior judge here. And earlier on, Judge Piet really reflecting on the requirements for a recusal, saying that you don't necessarily have to prove bias, but if there's any reasonable apprehension of bias, that is enough grounds then for a recusal. Also important to note that this entire process was initiated by Judge Piet himself and not the other way around, where a legal counsel brought forward a recusal application. Let's talk to Mpumelelo Zikalala, a legal expert, about again, just to remind the viewer that in no way clearly, if the 17th of April has been set down, will this lead to further delays with a new judge.
Certainly the matter is not going to start on the day in terms of the witnesses being able to lead evidence. I think it's also going to be housekeeping issues. If what has been stated today is indeed going to be true by Advocate Tilezi, then definitely we may see a postponement on that day and setting up of a date in which that particular application for recusal of Advocate Billy Downer will then have to come in. Now, it will come in this stage with a few more added facts. Now, previously, there was no case number which was attached to him. In this time, yes, there is a case number. He is regarded as an accused in a private prosecution. Other complaints, maybe within the LPC and other regulatory bodies, could still apply, and even a complaint within the NPA, because there's still that particular avenue. And then the most important question would be for the court: do you want a prosecutor who has all those things which are behind him and all these particular allegations which are behind him, being the individual who is going to prosecute this particular matter? But I think the most important question would be to the NPA. What is more important? Is it the retention of Advocate Billy Downer in this particular matter, or is it the prosecution of the accused, which is the former president, and make sure that things are able to move on in a much more quicker pace? That's a decision in which the NPA will have to come and sit and decide. It does not mean that if Advocate Billy Downer is removed as a lead prosecutor, he cannot sit in and be able to provide his institutional memory and knowledge that he has acquired over the years. It simply means that he is not going to be the person who is going to rope and be the lead sort of presenter when it comes to these type of cases. So it's certainly something in which the NPA will have to think about, certainly in which the team of the former president will have to go and build up this application and make sure that it has merits in order for it to be granted by this particular court. But definitely, on the next occasion, there's no trial which is going to sit. It's purely going to be for keeping matters and for further dates as to when that particular application must be set and heard by the presiding officer.
Added to that is the fact that there's still the matter before the Constitutional Court, where the former president has made an application for leave to appeal the dismissal of his special plea to have Advocate Billy Downer removed from the case. If the Constitutional Court rules against the former president, does that have any impact, or will they still have to approach the LPC, as you've said, and as well as possibly the NPA?
If my memory serves me correctly, I think the Court did deal with that matter, because it said we're not going to hear this particular matter. We're only going to deal with it on the basis of merits. We uphold the decision which was given by Judge Koen, which is why in this case he then came back and said, the Court decision which I was waiting for has been done and dusted, which is why I'm here saying now another conundrum, another problem that you may have is that I'm pronounced on certain issues. I'm not really fit and proper to be able to sit and listen to this particular due to those particular pronouncements. So basically, there's nothing impeding or stopping this matter from continuing. It's just that those new applications, those new facts, those new things in which then the court needs to consider will have to be considered by Judge Qhili in this case.
Should the public hail this as a positive move by Judge Piet, him initiating this process, applying his mind, seeking the legal perspectives of both teams. He mentioned that the Constitution, but his conscience dictates, as well as the trust in the judicial system.
This is exactly the type of judges that we should be sitting and having in South Africa. The judge is going to say, this is above me, this is not about me, it is about the law, the protection of the law, and most importantly, the protection and promotion of the interest of justice. If the interest of justice so dictates that I mustn't sit in a particular matter because I've made it in pronouncement, that's exactly what I should do. In fact, the laws allows it. So if this particular application is initiated by the presiding officer himself, it definitely means that he had foresight and said, I do not want to be tainted in another occasion. I do not want these proceedings to be tainted by technicalities. I want the merits of the case, when they are to be heard, to be listened to purely on their merits. There's nothing there they should come in that is going to change these particular proceedings, including me as a presiding officer. So if I've made those particular pronouncements, whether directly or indirectly, whether it was intentional or not, or had the foresight that this matter is going to take this particular turn, there's neither here nor there. But to protect the integrity of this particular court, to protect the integrity of the robe that I'm wearing, let me recuse myself from this particular matter, so that at the end of the day, everything is going to be according to plan, and every decision which is taken must be in the best interest of justice.
Mpumelelo Zikalala is a legal expert, Xoli, reflecting on the significance of the recusal of Judge Piet, hailing it as a positive step and exactly what the caliber of the judiciary or judges, the type of caliber that we should be having in the judiciary, in terms of the behavior of Judge Piet.
Zianda Ngobo, thank you very much. Live for us outside the Pietermaritzburg High Court.